Welcome. This is the Domain Name Law Show. We're here every Tuesday. That's noon Pacific, 3 p.m. Eastern. There's 3 co-hosts to this show where we talk about domain name law, domain disputes, and so on. My co-hosts are David Michaels and Jeff Neuman. David is stepping away for the month of August. He's got other things he's doing, and one thing he's working on a piece of software that really helps podcasts, and I look for him to, when he on his return, to use the software. We'll use it here on this show. Basically, it tries to even out, I guess, microphone and audio inputs. But I wanted to say hello to my other co-host, Jeffrey Neuman. He's here with me today. We got a new show format, and I'll tell you about it. Hi, Jeff. How's everything going?
Good. But you know what? I just realized that you don't introduce yourself. You introduce us, but then you don't say this is Todd Ryan. But I'm doing good. We'll talk about what we've been working on as one of the first topics. So I will save that for a minute.
Yeah, and Jeff, sometimes I do. I think sometimes I'll say, this is Todd Ryan, my co-host, but I agree most of the time I don't, but I know I do more often when I'm in the DNX room. But I think I'll make note of that only because, it sounds smarter when people are listening on replays. And by the way, we are on replay on YouTube, and then you can listen on Spotify and on Apple Podcasts. But I want to say thanks to those of you that come in here and listen. I know every week you got a lot of the same folks, but thank you, Larry. Appreciate it. I know you got plenty of things on your plate too, so always good to see you. And then KW, it's fantastic to see you. Arif is a mainstay, and Paul. So thanks, guys, and I see the rest of you too. I really appreciate you being here. It's nice to see you, King, and nice to see you, Zach. By the way, I did notice, well, I don't want to give it away, but I saw Zach.org was a name that's available. Geez, not even much. I think it was starting off at like $1,100. But GoDaddy has some liquidation auction that they're doing. And really interesting that this is the first that I've seen GoDaddy have what they call a liquidation auction, and meaning it's not their names, it's names from third parties. So they got a few sellers who were different situations in their career. Basically, some may need money for medical expenses, or people getting older and just wanting to get out of their portfolio, and it's just difficult to do. Well, GoDaddy offering something like this, I really like the idea, especially if they promote it properly, and that is, basically saying, hey, we got a lot of these names. These are some old age names, some great stuff. I don't have a link handy for you, but so search that, and you can find it on a few different blogs. But so GoDaddy having some liquidation auction, and it's interesting, like I said, because there's a lot of names starting at $100, and a few maybe in the low 4 figures, but as domain investors, that's what we look for. Are there any bargains? And of course, we got to compete with each other. A lot of domain investors know about the GoDaddy auctions, but the most end users aren't familiar with it. But I was going through the list and I noticed that one, Zach.org, and I thought, I probably already contacted Zach. I'm going to send him a WhatsApp. Hey, did you know this? And anyway, interesting. So check that out. Especially domain investors never know when there's a name you like that other people aren't feasting on. But Jeff, I wanted to start off today. I said, so really our format is changing slightly, and we shortened the show to 30 to 40 minutes because on replay it's just easier, and people knowing there's a cap on this thing, maybe I will listen to it. So I thought we would have a topic each week, and then review one UDRP case each week, and then question and answers. And like I said, 30 to 40 minutes. So if you have any questions, really about the topic we're going to talk on, the gTLD program, or any other questions, please raise your hand and bring you up here at the end. But the end is not far away. So once again, thanks for joining. And I want a quick sponsor, domainescrow.com. Okay, that's a service that we offer through JJN Solutions. But you're a domain investor, or if you're a broker and you have a transaction that you want, you need a little bit more security. You don't feel comfortable just selling to the other party directly for a lot of reasons. And there's plenty of things I think are important about having a third party get involved. But so take a look at domainescrow.com and tell us what you think, and then check out our fees. Very competitive, lower than some of the other services that you know. I first wanted to start off by a topic that I don't have on the outline, but Jeff, there's been an email going around, and I saw from a couple different sources. One was Elliot's blog at domaininvesting.com was saying he got a suspicious email from a guy named Will who claimed to be from Adam, and he basically was saying, hey, we see that you have a lot of domain names. We'd love to put them on the Adam platform. We have 400,000 plus brandable names. And Elliot reached out to Zach from Adam, and he said, no, that's not from us. And the giveaway, and I saw from another email that another person received, that was the giveaway was the domain name. So they didn't put a link in the email for you to click, but they were asking you to call them back. So always important to look at where the email's coming from. But Jeff, I know I'm just bringing up this to your attention, but when it comes to, I have some thoughts on it, but how do you, other than an email, I guess what I'm getting at is, why do you think somebody would send out this type of phishing email and want you to call them back? Where might they go with it if you did call them back?
Well, look, I think this kind of scam's always been, well, I should say always, but has been around for a long time. You constantly get it from banks, or you'll get it from people claiming to be suppliers, or, you'll get it from anyone who does trademark law knows that once you file for a trademark, you'll get these notices that look like they're official notices from the U.S. Patent and Trademark Office, but what they really are law firms that, not really lawyers, I guess, that want to do your work for you and get you to transfer the names to them. It was done by registrars or people masking as registrars. So this kind of thing is common. It's not surprising to me that it's just starting, or that this is one of the first instances you've heard about it. But yeah. So what was the domain that they were using?
It was on a .co, and I believe it had Adam in the domain name, maybe Adam hyphen something. I know there were another one that I did view in email. You could tell it wasn't from atom.com. So that is a first, dead giveaway is what I say. Now, I think with an email like that, now it's weird that two different parties I see that have received it. So I'm assuming several have. Adam does offer sort of an affiliate program, a referral program. So it could be someone who is basically wanting to have you allow them to submit your names to Adam. What I'm getting at is it may not be completely phishing. It's not being upfront with you. They're certainly not from Adam, but they could be wanting to get your names on that platform and get an affiliate fee or a finder's fee for doing that. Because I was just looking through the email that Elliot posted and was thinking, and I know, I did say Elliot, right? Yeah.
Yeah.
So I'm just trying to think. So what are they trying to accomplish in this email? But anyway, the moral of the story is always check from where the email's coming from. And then, like Elliot did, you have a contact over at the place, call and say, was this from you? And they said no. And it was Ryan Ewan who also got another email, and he posted online, and Darpin immediately responded on X and said, no, that's not us. But interesting. I mean, that's nice in the community sharing these things, because some of us are busy. You get an email like this, you don't pay attention, and you really do need to look at the specific email address. But we know sometimes in our email providers, it just gives you the name. It might just say Adam, and you don't click to see what is the long address. But anyway, let's jump to our topic for the day. So Jeff, we've been overwhelmed, and I mean JJN Solutions has, because one of the services that JJN Solutions provides is helping applicants, helping companies, entities submit their application, prepare and submit their application in this new round. Knowing, I guess I wanted you to give a little background. I'm saying sort of explain to folks the differences between the three primary applications, and that is a brand. Even though folks know, I know there's people listening on replay, because we're going to talk about this over the next few months, because the window closes tomorrow, meaning you have to have your application in, and that goes for all types of applications. A brand application, what we call it, a community application, or an open application. And then the reveal date we're expecting, well, they're saying mid-October, and that will be, they'll list, here's all the extensions, all the strings that were applied for, and here's all the entities, the companies that applied for those extensions, and then we'll see, oh, that one has multiple applications for that same string, and then there'll be auctions. But tell us, different between these three types of applications: brand, community, and then open. You're on mute. You're on mute, and you sound good on mute. Real good, smooth. Okay. When I'm listening to something like this and I hear people down, okay, and they're like, fine, I don't mind. It's like, okay, I'm drowning now. I'm going underwater. I've fallen off the boat. Jeff's the lifeguard, and he's not around. All right, Jeff, you're still on mute, but I'll say, okay, just come off mute when you're there, and we'll test it out. I'm assuming someone came into your office, either family member or a dog. Okay, so come off mute when you can. But to tell you specifically, so brands we know, and that's a company that has a trademark on their name, just like how Amazon did, and then they go after that extension. And you're real limited, meaning it's not an open extension, so you're limited on how you can use that extension, because if you're not offering it to the public, then you, I don't know what happened there. If you're not offering it to the public, then you basically have sort of a narrow use for the extension. I'm really wanting Jeff to talk about the community type of application, because I've learned a lot, very involved, very specific. If you're a community, and I think of, like, for example, like tennis, a tennis federation, and they would want .tennis, and what do they have to show to be able to accomplish something like that? Once again, Jeff, if you're at your mic, come off mute and we'll just test it to make sure everything's okay. The case that we're going to be talking about today, .net, is a big Canadian company, and there was a Canadian domain investor that purchased the name. I'm assuming domain investor, maybe just a business person, but I was curious if you've ever heard, Arif, since you're in Canada, and Zach, ever heard of Roofmart? Let's see here. Because they're the okay, so I'm sure you can hear me. Fantastic. I don't know. Was I?
Oh, wait. So
go ahead, Jeff. I was saying, so there's brand applications, community applications, and open applications. Explain those briefly.
Yeah. So sorry, I didn't realize I was cut off there. Um, yeah. So the open applications are ones that are, again, just like it sounds, they're going to be open to everyone. They are usually have no restrictions. They're like, the dot photo and dot a thousand others that are out there. The dot XYZ dot, yes, dot club is in theory you think about for clubs, but it's technically an open TLD. Those TLDs, I consider, are probably some of the easiest applications to do, although that can be complicated by the fact of, is it an existing entity, a new entity, a joint venture just set up to apply for this, and there's that could add lots of wrinkles and complications to it, making sure that your financials are intact. Um, Brand applications are just what it says. They're for brands to mostly use internally for their own purposes or could be for their customers. Um, those are closed top level domains, meaning that only the brand can register names in them. Or when I say only the brand, it's a brand or affiliates of the brand or licensees of the brand are the only ones that can use the top level domain. Those can get complicated because the bigger the company you're helping, the harder it is to get certain details out, or the weirder ICANN's processes seem to these companies. So getting a large private company to disclose its very secret financials is difficult. Um, Also, they're not used to giving out details about their board of directors or their shareholders, things that are required for background checks and others from ICANN. So, in a lot of ways, while the application may have similar amounts of fields to fill in, I think the brands are difficult applications because of what you have to kind of go through and all the processes and procurement and all this other stuff. Then you have the community top level domains, which one applies as a community because if you do and you're the only you succeed and you're the only community applicant and there's other applicants, you will have priority and it won't go to an auction if you can pass this community priority evaluation. That's a difficult application because there's a lot more fields to fill in. There's a lot more evidence and proof points you have to put in. There's research that needs to be done, in some cases surveys. So they're very involved, and the couple that we're working on now just take up a lot of time. So we'll like you said, we'll kind of see who applies for what in a couple months. But yeah, I think I'll get a little bit more sleep hopefully after tomorrow.
The interesting, like you say about the brands and what I've learned working with you on this is absolutely right that some of these brands, big private companies, and they're wanting to know specifically, and we have to give them answers, who gets to see all my financials? And, ICANN hires auditors to help them. So there's big accounting firms, but then, like I said, the applying entities wonder, well, okay, so that could be an issue for us. ICANN, and so this is private. I mean, this is information that's not going to be public. ICANN's not going to list publicly, but yet they're still sharing it. And ICANN really in a position where they don't negotiate a lot on their terms. Here, how this is going, either yay or nay, and then we can explain that large companies have done it in the past, but yet
And their terms are all very one-sided in ICANN's favor. So if you imagine big company X is normally used to getting its way when they negotiate contracts, and it's usually one way in favor of them, to now have to disclose all this, like your most secret confidential information to ICANN without getting any contractual protections from ICANN or any indemnities or anything like that. If ICANN were to accidentally release it or accidentally disclose information to people it shouldn't have, you know, these big companies are like, who does ICANN think they are? We're a company, we're a large company conglomerate X, and we normally dictate the terms. And getting through and sometimes having to get all the way up to executive sign off, um, and in some cases CEO sign off, in order to be able to disclose this information. Um, it really kind of it's humbling when you're talking to these executives and others saying, yeah, I know your concerns, and I know ICANN's not promising you anything in return. That yeah, they say they're going to try to keep your information confidential, but there's no guarantee. I know that's not the most comforting language in the world, but if you want the top level domain, you want to apply, this is what you got to do. And in one case, we, as you know, Todd, we had a client that initially was going to drop it all because of certain concerns they had, and we worked out a solution in that case. But it was pretty touch or go. But they really easily could have said, no, forget it. And we were all the way through their application process.
Yeah, it's humbling for the large companies because you're right. We're, speaking to the C-level team and the big bosses, and we tell them that's just going to be how it is. They're like, who's ICANN? They know a little bit, but usually there's a team underneath them that are helping prepare these applications. So by the time we need things authorized by the executives, they're just, we decide. And we're thinking, not in this case. As a matter of fact, Kentucky Fried Chicken, we need to know your secret recipe. In Coca-Cola, we need to know how you make. No, but ICANN really is non-negotiable. They here's the terms, you go by it. But it is interesting. I think brands, what I'm noticing is brands have some great ideas on how they intend on using their brands this time around. We know last time a lot of brands applied, and then they just let their brand, basically they just let it expire or didn't continue on with it. And I think there's probably going to be a heavier number of brands. Well, anyway, Jeff, last time about 1,200. Was it 1,200 to 1,500? I can't remember, and we went over this so many times early on with companies about how many different strings were applied for last time. What was the number, and then what do you think will be the number of strings this time?
Yeah, so it was 1,930 applications for somewhere around 1,230 strings, something like that. I think this time around, I don't know. There's a lot of people, or I should say a lot. There are some companies out there that have basically said, oh, we're going to apply for 100 or 200 or whatever. And you don't know now if they're all talk or if they're really going to do that. Anecdotally, I've heard that some of those companies are in fact going to apply for a large number, but anyone that says that they know the amount of applications really is just pulling from thin air. Who knows? I I tend to think that we're not going to get as many of the purely generics, but I could be wrong, right? I think it's more ripe for brands or um, more narrowly tailored strings, but there's going to be a couple that we all probably could picture will be applied for, and I'm happy to say that none of our clients are applying for any of those strings that first come to mind, which I think is a good thing. Um, but every day I'm seeing a new announcement. Like I think I saw one yesterday from someone who was applying on behalf of a community for Bitcoin. There was a news article on that. Um, so we'll see. Who knows how many there are going to be?
Right. I saw that. I don't know what it was. It was like a news release, but I know if you saw that, and I didn't know you did. It's good luck. Good, apply for it, and if you got all the community stuff you need in place, if somebody else is applying as a community domain or TLD, I mean, Bitcoin, unusual. I don't know if there would be more than one even community application. There certainly could, but then you could see companies wanting an open application for that. But that's like at this point. So it's done. Basically, the window closes tomorrow. It's pretty interesting, get to see it behind the scenes. And that is, we've submitted most all of the applications. Now it's really done. Just hit a submit button as we finish up and let some of our clients review. But it really is going to be exciting in October because we all want to know, all right, so which ones were applied for, which ones, basically as long as they're not contentious. So it's like, hey, that company applied for that. Looks like they may get it. There's still some things that get checked out. By the way, I do see there's some people that have applied, some entities have applied for names, and the last date for payment for people, it doesn't matter to you if you didn't apply, really is August 19th. So that's when you have to make your payment to ICANN. So there's been companies who have filled out applications, but you still got to pay that invoice. And so there's companies you could try to, work with pro bono consultants, or I guess what I'm getting at is companies going forward trying to spend no money applying, getting in their application in time, but there's still, check that has to be paid, basically an invoice that has to be paid. So there will be some applications, people don't come through with the money, and then, so, all for nothing, but, they, still trying to get finances arranged, and anyway, that ship pretty much has sailed if anybody doesn't have their financing in place. And okay, so we'll revisit the gTLD stuff because the window closes tomorrow. The reveal period is really an exciting time. Jeff, I was hoping at NamesCon, I saw there's a panel that's going to be discussing the next round. Basically, by November 11th, 12th, when NamesCon is, they'll be able to say, here's what extensions were applied for, here's how many, and so on. Did you see? I didn't see. That's a panel that well deserved you should be on. But did you see who's on that panel? There was a couple people. Of course, Joe at IT, I know, and there was somebody from ICANN who I do know. I can't even think of who it was now. Maybe, and then a couple other folks. But did you happen to see a post about that session at NamesCon relating to the gTLDs?
I didn't, but a lot of times they kind of stack their panels with people who sponsor the events. So, IT.com and Joe are sponsors. ICANN tends to be a sponsor. So you're going to see them on the panels before you see someone who hasn't sponsored. So, it doesn't surprise me, and it won't surprise me if they have people on there that, didn't really help too much in the round, but, pay to play sometimes.
Yeah, no, you're right on there. Well, they did, I'm going to be doing a couple things at NamesCon. One is roasting the industry like I'm going to do at the ICA event in January. And by the way, for both events, if you haven't got your ticket to NamesCon, just go to namescon.com and you can use a code that they gave me to share to my colleagues, TR, as in Tony Ryan, as in Todd Ryan, TR20, and you get 20% off your ticket. It's pretty good. And then also you can go to icavegas.com, but there was at ica.vegas. I always go to just internetcommerce.org because I wanted to tell folks two things. If you're a member, I'll see you on the call next Wednesday. We have an ICA call next Wednesday. It's 9 a.m. Pacific, noon Eastern, and then that's in my estimation for most of Europe at 5 p.m. But we're hoping to see a lot of friends from Europe. So trying to make it, I know people, it's tough over in India, but still, that's only, I think it's still 9:30 at night then. So I think a lot can join then. But trying to just really make it reasonable for all the different areas of the world. But I say that because looking forward to, seeing my fellow members on that call. But if you're not an Internet Commerce member, go to internetcommerce.org. It's a perfect time to join, and then you can, then introduce yourself, but be part of this call next Wednesday. And then I said, our next annual meetup in Las Vegas is end of January. So you can see all that information at internetcommerce.org as well. But yeah, two events that I'm looking forward to. So NamesCon, I'm having a talk with some of the guys over there, basically the organizers, Anthony and Christian, about there's a couple stages. There's a lot of sessions that have been decided, but there's one that I was proposing about letting people ask questions to the lawyers, not just that they're wanting to have one stage where you can interact with the stage. Basically, is there demos, or basically you just don't want to be talked to. Sometimes we're there at these, events, and it's like somebody's got their little presentation for 20 minutes. They've been, busting their ass getting it ready, and they're telling you it's like a class, and you don't get to say anything. You just sit there and I guess have to believe what they're saying. And anyway, there's plenty of those sessions, but they're like, we wanted to equal it out this time and have interactive sessions. And I said, no better than to have some attorneys there from our business. And I was really hoping to Jeff, Zach, and Jason would be my three I would like to have the audience be able to ask questions to, from new things like rentals, things to be concerned about when you're renting a domain name, because some of the platforms are doing it, to things like, hey, you're outbounding. What are things to be aware of if you're a domain investor and you're outbounding, and really just open it up to any questions. So it's not legal advice, but as close as you can get. And I think a panel of attorneys is perfect for that, for interaction, because we don't like just to be told what to do by lawyers. But so that's something that I'm gonna spring on a few of you guys after a call I have next week to say, hey, how you into doing it? Are you going to be at the show? But so that's in November. I want to get to this case, and then any questions, raise your hand, come on up, and we'll. In this case, there's a company out of it's called roofmart.net is the domain dispute we're going to discuss, and the company and the domain owner are both Canadian entities, or they both live in Canada. So the company, well, let's see, what is the actual name of the complainant? It is Roofmart Limited. Okay, Roofmart Limited. And I was curious, later on, Arif can tell us, and anybody else that's from Canada, Zach is here, have you heard of Roofmart in Canada? They made themselves sound like real popular and real well known. They've been around for a long time, but this domain owner also had Roofmart. He registered roofmart.net not long ago, a few months back, and it, didn't really have the site resolving anywhere. But I'm going to throw it to Jeff, because Jeff, our own Jeff Neuman, was the panelist in this case, sole member, single panelist, and this company, Roofmart, put together their complaint. It was sufficient, to move forward, but interesting how Jeff analyzed it, and I'll go into some of the comments, or basically some of his findings. But Jeff, tell us a little bit about this case. Roofmart.net is the domain name, and the complainant is a large Canadian company called Roofmart.
Yep. So RF put his hand down or thumbs down. So I don't know if that was to the question of whether it was well known. Look, I'm from, regardless of whether you think you're well known or you are well known, you still have to provide proof. You can't just make an assertion. And in this case, the complainant not only made the assertion, but it filed two declarations or affidavits, one from its in-house counsel and one from its outside counsel, saying, yeah, they're famous, they're well known, they've been around since I forgot the year, 1970s or something. So they kind of, I don't know. I'm in the United States. I'm an evaluator. I have no idea their size, and they really didn't submit a whole lot of information. Just those two declarations saying, they swear under oath that they're been around for this long and that they're well known in their industry. Um, but in this case, the respondent did not reply. So as you go through the analysis, right, you look at the first element. Does Roofmart, the complainant, have a trademark? Yes, they do. And is this? Sorry, did I say Roofmark? It's Roofmart. Um, but and then you look at whether the domain name is the same, identical, or confusingly similar. And it is, right, because it's the exact mark. So they get past that first element. The second element is whether the respondent, you have to show the respondent does not have legitimate rights or interests in the domain. And the complainant basically put out its what you would normally put out as prima facie case. They said, well, they've never licensed it to the respondent, their mark. Um, there's no information that indicates that this is, that they're known as Roofmart, and there's no indication that they're using it for a bona fide purpose, a bona fide sale of goods and or services. The one thing they did have is that the respondent was identified its organization as RoofMart. But that's it. And, yes, someone could argue, well, their who is information says that they're RoofMart, but, just looking at who is, the information you provide your registrar, just because it says, RoofMart as your organization doesn't mean that you're commonly known as that. And because the respondent didn't respond, the second element is kind of at this point, you know, I skipped it. I didn't make a ruling on it because really what ended up holding the day was the third element, and that is bad faith. Did the respondent register and use the name in bad faith? The complainant said, well, they haven't used their site since they registered it, and all I'm getting is a 404 error. So it's inactive, it's passive use, and there are cases out there that say that use or non-use of a domain name can be considered or could be evidence of bad faith. What the complainant didn't do, and what a lot of people, when they read the line of cases that talk about passive or inactive use, fail to do, or realize is that, look, that's just one element. You always have to look at kind of the totality of circumstances. And yes, the name's not being used. Okay, that's one factor. Now let's go deeper. Have they ever tried to sell the name? Well, there's no evidence of that. Have they ever sent out emails trying to impersonate them? No evidence of that. Um, is there basically any kind of evidence in the record that would show that the registrant, or sorry, that the respondent, the registrant, is trying to interfere with or target the trademark owner, trade off the goodwill, anything? And there really wasn't, other than the fact that it wasn't being used. And so, look, the respondent didn't respond. I have no idea if they registered it with good intentions or not. But at least the way this complaint was worded, even though it was a law firm that did this complaint, it just didn't meet the totality of circumstances test in my book, and so it was I denied it for all of those reasons.
Well, interesting. So Jeff denied this complaint, and this was a gentleman registered roofmart.net. The complainant is on roofmart.ca. Roofmart.com doesn't resolve anywhere. But I think some panelists would have transferred this domain away. What I like about your decision, Jeff, is one thing that you summarized in the decision was the panel does not determine that respondent acted in good faith. You're not saying that he did it in good faith. You're just saying there's no proof that he registered the name in bad faith. Then you put, or that respondent would necessarily prevail in a trademark infringement action. That's something separate. You're just saying that, and you said it in the decision, that panel finds only that the evidence submitted in this streamlined proceeding is insufficient to establish on the balance of probabilities. So the complainant was saying about, hey, passive holding, you're all about listening to the complainant, but you're saying that's only a piece of it. There's more to it. There's not one thing determines, bad faith. And in this case, really, you did say just the popularity of your mark. You didn't, you're just saying you got a website, here's your history. All right, but that doesn't tell me about the popularity of the mark. And if I don't have it, I don't have the evidence. I don't have the evidence. But I think it looks good that Arif and a few others in the crowd were doing a thumbs down, meaning they hadn't heard of RoofMart, because I wouldn't know. It could be super popular up there. It's like RoofMart. Of course, everybody gets a roof done up here. But Arif, what do you know about RoofMart? Anything?
Hey guys, well, I'm in Quebec, so most brands have a sort of translation, like Staples is the French version is Bureau en gros, which retranslates back to like office bulk or office wholesale or whatever it is. But I've never heard of RoofMart before. But I'm just pulling my hair out here because Jeff correctly interpreted the nuclear marshmallows in that it's not automatic, right? When the nuclear marshmallows case came to be, there was 5 separate and cumulative reasons why the panelist, said passive use is this such and such. But he was very stressed, very importantly, that there was 5 reasons in that specific case why passive holding was seen as to be maybe a little bit a little bit more justified to take the domain away. But there's other cases where it's just the panelists just they go nuclear marshmallows, passive holding, and you're holding it passively, and all those other finer points are not taken into consideration. And my case was very frustrating, but there's many reasons why it was frustrating, but that's one of it. And Jeff, also you mentioned proof of actual strength of the mark, and there are times when there's no proof, or even worse, the proof is like circumstantial at best and nothing really solid. But if somebody doesn't reply properly, or in some cases even when they do reply properly, they'll still take it as we'll take it for granted that it's popular, right? Because we don't have to check, just we'll take the word for it, or we'll assume because it's a big company that they must have heard of the sub brand. But the reality is that it's not the parent company that's in question. It's the mark, right? And sometimes those marks can be very tiny and unknown. Anyways, I'm rambling, but I'm happy you're one of the panelists out there who actually cares to look things up and take things with a little bit more care, to not take it at face value, because there's just too many cases where that's just not the case. So sorry for rambling, but it's just it's yeah.
Any response to him? I know you say you're not familiar with RoofMart, Arif, but I have a belief that you're probably familiar with roofies. I don't know why I have a terrible joke like that. It's terrible to say.
Not
Okay,
even.
Jeff, Jeff, what response do you have to Arif?
I think that's exactly right. I think that there are a number of factors, including how strong the mark is and whether there are other conceivable uses for that term. And so, a lot more goes into it. And he's right that there are some panelists that overlook that, especially when there's a default on the respondent's part.
Yeah, and before we go to Brad, if there's anybody have any questions, the last 5 minutes we're just gonna have a question and answer, unless there's more questions. But it is true, Jeff. With this decision on roofmart.net, Jeff denied the complaint. He was open to could be it could be cyber squatting, they could be targeting, but there's no proof of it, so that could be you can't he doesn't rule on a could be, but so there's just some things missing there. But many times when a domain owner doesn't respond, the panelist just really takes it as you're guilty, and I like that Jeff doesn't, and some other panelists don't either. They still look at the evidence and rule, on the evidence. Thank you, Brad, for joining us. What's going on?
Hi, thank you, Todd, and thank you, Jeff. First, the domainers would love to have you, Jeff, on any of their UDRP cases, because the way that you opened yourself up to allow the possibility that the domain investor didn't have bad intentions allowed you to expand this to where you went over these 2 law firms. You know what I mean? And I have a couple questions. One of them is, you had mentioned that when you looked at it, it was a 404, so it wasn't for sale. If it was for sale, would that make a difference? Number one, I have a couple. Would it matter to you if there was a for sale page?
I think that would have been a factor, sure, but again, they still uh, it's the totality of circumstances, and they would have to show that there was some sort of targeting. But certainly, you add in the factor of a for sale page, or if there were, copies of emails that were sent out, or just something else, or other factors, those would all be considered. I can't tell you that if it had a for sale sign that it would definitely be. because it depends on everything in the record. Also, remember that this, or I'm not sure I said it, but this respondent actually is in Canada. Um, so that was kind of interesting, and it was something I thought about, and especially one of the reasons for that last paragraph, because it could very well be that this company is well known, and it could very well be that this respondent knew of this company, but there was just no information in the record for me to make that kind of assessment. And I
Yeah,
I
your
lost
audio
you there.
stopped for a second, Jeff. Yeah, same to me.
Awesome, too.
Lost him for a second. I'll tell you what I've started doing with mine. My having closing certain apps and not having so many things open. My audio and
But
my
you know
streaming is
another
going much better now. But Jeff, hold on, Brad. Let's see if Jeff, are
okay,
you there? Might have to. It just locked. It shows that you're not on mute, but
right. I
now try
but
it.
just as another question when he comes back is, could it have been that it was preventing the the trademark owner from using it? You know what I mean? Not that he intentionally targeted it or anything, but since he bought it, could it have been construed that having the mark similar, he prevented the principal company from acquiring that name? You know what I mean? Is that an issue in this?
I think,
And then
well, Brad, I was going to say, and he'll get back in here, but you did have that previous question and this question are good questions. And I think they would have been then tilting it more towards the complainant, but I think the decision probably would have remained the same because that would have just been part of what's going on. Meaning, sure, like to have a for sale lander, all right, but that still doesn't change the fact that the complainant wasn't sufficient in providing evidence showing, like Eric said, the strength of the mark. And
yeah,
then go ahead, Jeff.
yeah, I was gonna agree with that. That there's always factors that you can. It's a totality of circumstances. So the fact that if they actually, because they were from, the respondent was from Canada, uh, and if it was for sale or if there were other factors in there, then sure, that could change the dynamics of the case. And it's really about looking at all of the circumstances.
right, like I mean, for example, if you found out that the guy who owns the .net, used to work for the company, right, and then that would be a clear indication of something.
Absolutely right. But
Yeah,
you
no,
know,
I understand, but I have then just two more things real quick. One of them is that isn't it kind of a generic term, roof mart? Like it's a perfect geo type of name that anyone would like. And when was one registered? When was the .net registered? Before, prior, or after the .ca?
oh well, I mean the certainly the dot net was just a couple months ago.
Oh,
Um,
okay.
and then the trademark is around since 1970s. So it's certainly been a long. This company's been around. Roofmark has been around for a long time. Whether it's descriptive or generic, uh, I mean that's there could be other uses for it, but um, that I
Right,
didn't have to
right.
make that call.
Okay, the last question. This is kind of a weird one, but the way that you explained it was, did any part of your decision have anything to do with the fact that they tried to oversell it? They could not only one law firm but an outside law firm, and in fact they didn't even do a good job. Were you like considering like the way that they overdid it, or they blotched it up and that added to the lack of credibility of their claim?
I don't think that added to the lack of credibility. I think it was just self-serving, right? That you
Uh-huh.
file these declarations that's from the company itself and from its paid outside counsel. That the declarations just don't mean much um, on that aspect when you can easily show of fame or proof of being well known. Throw in all these news articles, throw in, your amount of sales that you have every year, the amount of customers you have, how, the marketing you do. There are
Right.
all
Any
these things that
ads
you
or
could put in.
whatever.
Right. And so, but they didn't. And all they put in were two, the website itself and two self-serving declarations, and that's just not enough. So I don't think it was animosity or holding it against them. It just wasn't crediting that much the affidavits or
Right, right. I
declarations.
mean, and someone of your incredible experience and expertise in this lasered arena, you knew that they were missing some of the key simple elements, right? I mean, they get these big law firms that actually didn't know what they were doing in this particular case.
Yeah, I can't argue with you there.
Thank you.
What, Brad, thanks for the questions. Right, the domain investor was allowed to register this, right, a couple months ago. So we know that,
Well, we don't know he was an investor. We have no idea who this
right,
person is.
right again. And I said, right, he could own very few, didn't do research to find out with some of these tools, does this registrant own a ton of names? But when, we know as domain investors, the registrars, they allow us to register some names that include, marks, and it may be an obvious one, like we know Coca-Cola, or it may be just one purple, and you're registering. I think I sold Purple Saturday one time, but it may include a mark that's a company uses, but you're not using it anywhere near them. But like I said, even with Coca-Cola, somebody could. That's really a tough one, but you'd have to really show a non-commercial use of it as a review site, and it's still that some of them are just super trademarks, very difficult for you to prove that you have any right to it at all. But the point is, roofmart.net, yeah, guy could have registered it because it's generic, pretty much generic, but it's just that I like that Jeff decided on the evidence here and knowing we don't know why they registered the name without them answering. They could have hurt themselves by answering, and they certainly they could have answered and gave away some information of why they registered it, because they could have said, well, I know that I thought the name was great, there's a Roof Mart right down the street from me and I had used them before. I mean, could have stepped on their own toes of saying, yeah, I thought of them when I had it, and I thought if I never build it, maybe they'll be interested in buying it from me. Well, then now you're opening up a whole new can of worms, because then they're saying, well, were you planning on building it? If you were, we know with domain investments, anyway in the UDRP, they expect what steps did you take to turn this into that idea that you had. Anyway, he didn't answer, and since it was a complaint that was had a few holes in it, Jeff didn't say that you can't go after him in another capacity. And Jeff, about if they wanted to refile a complaint because they're like, we do have evidence to show that we were well known, would that be substantially different than this complaint? So then a service provider would allow for them to refile?
Well, look, it's up to future panels as to whether they allow them to refile. Some panels will say no because you had that information available to you at the time you filed the first case. So no, we're not going to let you refile, or we're not going to consider it. But if they found out more information, or it turns out that this registrant now comes to them saying, hey, I won this UDRP, now pay me $1 million, that changes, then they could certainly refile based on that.
Okay. Should I go ahead, Eric?
You have a question, comment. I mean, look, I would say that Roof Mart is not like 100% generic, but it is, there is elements to it that is. And also, I think, I was wondering, like roofing companies, they're almost always local, right? And so, like, even somebody could have it, and could be bought in other parts of the world where there'd be no conflict whatsoever between the two trademarks, because, like, say, one's in Canada, one's in Australia. Like, if you're a roofing company, just by default, by the nature of your company, you're not doing roofing in Canada and in Australia, right? It's not a reality. Is that something would be considered as well?
Yeah, the market that you're in, absolutely, and what the trademark covers, and um,
But I mean, as like
all that
let's say
stuff.
it was a domain investor. We don't know what it was, but say it was. I mean, the argument could be said that like probably like for me, Roofmart to me, I would get that as a generic, right? I wouldn't even bother because I could see there's so many potential buyers for it and so many geographic locations that would be non-conflictual that like I wouldn't even bother looking because even if there was one, there are many other potential buyers in other geolocations who would not be conflicting by using the same mark because it's the nature of the business is like it's not international. But I
Right. No,
mean,
but it's an excellent lead generation, and there's a lot of companies now.
but the company in question is not a lead generation. That's why I was asking because
No,
it's
no, I
not.
understand, but the term itself, they conglomerate all the information and they contract it out to local
No,
roofers.
yeah, I know, but I just want to know Jeff's like if that's something would be considered because like it's somebody could hold it and sell it to be like literally hundreds of other people who could buy it in different geolocations. That would not be conflictual with that mark only in Canada, right? Is that something that's an argument
This
that would be
the,
viable? Or
the scope of protection, the geography of protection is a factor that you would look at. So yeah, so if it turned out that the company's in Canada, but the respondent is in Singapore, then
yeah,
that's
okay,
something
but
you would
let's
absolutely
say
think.
let's say it was me, right? Let's say I got Roofmark myself, right? I'm in Canada, but I'm also aware that that the main most of my sales are outside of Canada, right? And I've never heard of Roofmark before, but let's say it was a mark. Maybe I was whatever I looked up and it was there, or something I might have heard in the background in the past. But knowing that like they're operating within like one city or one province within Canada, and knowing that my potential buyers are likely outside of Canada, United States. There's many different states, or international. Again, Australia, New Zealand, or UK, or whatever it is. Would that be an argument that I like would hold weight for me because I'm a domain investor, or is that like it would really the other factors would be more of a factor for you, and you would kind of ignore that? Does that make
Um,
sense?
yeah, it's hard to say whether I would ignore it. I just, it also would be like, well, you thought it was a good name because someone in your jurisdiction used it, so you're still trading off the
But
goodwill of that.
yeah, but the thing is, like Roof Mart is a good mark, right? It's like I like, even if there wasn't one. That's I think where the problem comes into play, right? Is that specific mark I think is borderline, right? Like I mean, if it was a very popular brand, then you might go one way and go, yeah, you probably heard of that and you got it for that reason. But if you've never heard of it, if it's not a big popular brand, like it is probably the case. Like again, I've never honestly heard of them before. In that case, you'd be like, yeah, I just saw Roof Mart. There's potential other customer. In my mind, it wouldn't even be other customers. It'd be like, yeah, there's plenty of people all over the world who could get it. It's one of
But
those ones that,
but you don't know the plans of this company as to whether they are expanding into other countries, or they may be there, or they may be in process of being there. It's not a strong argument, especially because you admitted that you'd heard of them.
okay. But I would say I hadn't. Like there's no reply in this one. Yeah. So anyways, like I know it's pretty gray zone, but
Eric,
I'm
let me
just
say,
because like
I understand where you're coming from too, because Food Mart that's too generic. Roof Mart, it's on that line. Could it be generic? Of course, we
yeah.
know it could. But if there was a big company, that's like with Home Depot. Okay, that's a little. I mean, obviously a brand, but just that Mart. If it was Floor Mart and there was a big company, or Lighting Mart, but we know like Lighting Market, because I agree with you. Some terms go with Mart. Like I said, Food Mart. There's
Yeah.
everybody's named Food Mart, so you could certainly jump on that. But Roof Mart, I think it's almost the registrant need to be careful on. So why did you get that specifically? But I understand what you're saying. Hey, I got it. If you did answer and you're saying my defense was, for one, I didn't know about them when I registered the name. Now I'm familiar with them because of the complaint, but I got it because even if I thought there is a company named Roofmart just in Tennessee, I might be able to sell it to somebody in Florida now, unless they have a registration at USPTO. But many times it's like we know there's a lot of companies that, the geographic area that they service does matter. But just saying, there's just so many facts involved. If you knew about them, and then you knew about them, what if you knew about them but you didn't know they were expanding internationally? All right, well then you're still, you didn't know. But it's a lot of intricacies of these issues, but more so that particular name, Roof Mart, I thought too, if it was Floor Mart, it's almost unique enough because that first word you don't see with mart a lot, but also that word, market or mart, we feel like that can go with any, what if it was car mart, all right, it seems generic, but I mean, it's like a,
How about if it was tooth mark?
tooth mart,
Teeth.
teeth mart, yeah, I mean, weird, but I'd say if a company, what they should have done, and Jeff was allowing this company to do it, if you've put a lot of money in your advertising and you think you're well known, and show us as much as you can, because, right, if you had Teeth Mart and it was somebody selling dentures or selling, and they put the money in, they can, try to make their case. But I think both sides, when you register the name, you're running the risk as an investor of somebody come after you. But when you're a company naming yourself that with Mart at the end or Market, or there's some companies that have company at the end of their name and they end up being well known, but it's just a generic term. All right, so
Right, there's nothing creative or novel about the name.
Yeah, no, you're right, and it is somewhat generic.
It all comes from Kmart, right? I guess Mart, like Kmart, do they even exist anymore? They don't exist in Canada anymore, Kmart. But
no, they're done.
States, does Kmart still?
No, they're done.
They're done.
At Blue Lights. Hey, thanks for joining us, everybody, on Thursday on the DNX show. Got a lot of topics, and one of them, when I see Ish's icon down there, it made me think of his post recently, and Costello's post about GoDaddy is going to do their appraisal. I agree that it can never be good, and why would anybody get excited like, hey, they're coming out with a new one? I wouldn't get excited about it if I was, even if I was a domain owner. They're going to make every name 1.5 million. But anyway, them coming out with a new version of their appraisal service, we'll see, when it hits the ground. But we're going to be talking about just in general, obviously those type of services, but then everything else domain name related. Josh is back from his vacation. He's moved, all settled in. Can't wait to share what he's been doing with DNX as a registrar and his own personal buying and selling recently. So we got a lot to cover. That's Thursday morning, 10 a.m. Pacific, 1 p.m. Eastern. I don't know if Dave and Anita are going to do a show tomorrow. If you want to give a thumbs up, Dave, are you guys doing a show tomorrow? Because Dave and Anita have been doing a domain investing program, podcast here on X, like 9 Pacific or 9:30 Pacific. I don't see a thumb up from David. All right, stick that one. But you can catch Ish causing all sorts of controversy on Saturdays. I'm just kidding. I try to get in there and cause some myself and then say, I don't know, I point around to other people. But that's a good show, Saturday. Oh, so Dave is going to do it. So good. So that means we got, yeah, go ahead.
Dave, put another thumbs up if it's noon Eastern time or 9 a.m. Pacific. Thumbs up.
So it's not X Twitter, or I'm sorry, domain Twitter is pretty awesome. I mean, especially we got this, and like I said, we're going to start, we went for an hour today, but we're trying to keep this 30 to 40 minutes and just go with a topic, a one dispute, and then some questions. So we're going to try to keep that. And then if the questions are good and people want to talk, we can go on a little bit. But glad to see Dave and Anita doing that on Wednesdays, and then Ish's Mainstay show on Saturday mornings, 10 a.m. Pacific, 1 p.m. Eastern. Always good. So if you can't catch things during the week because of your schedule, got catch up on Saturdays. But thanks a lot, everybody, for being here, and thanks for listening on replay. We'll catch you next week here on the Domain Name Law Show. Take care.
Thanks, guys.